Unlike the continental systems, English tort law does not consist of a structured, codified system of general rules. Instead, it consists of many separate torts. However, in the course of the 20th century, the courts developed tort of negligence into a general liability rule. Due to time constraints, I will cover only the most essential torts. Negligence, as a tort, is a breach of the legal duty to take care which results in the damage to the claimant. It has three main elements: duty of care, breach of that duty, damage, and causation. The duty of care implies a relationship between the claimant and the defendant before infliction of the harm. The most famous generalization of the duty of care was provided by Lord Atkin in the case Stevenson's versus Donahue, where the House of Lords held that manufacturer owed the consumer a duty of care for latent defects. The Atkinian neighbor principles implies that someone owes a duty of care to everyone who, by negligent conduct, can suffer foreseeable damage, provided that there is sufficient proximity between the wrongdoer and the victim. However, Lord Atkin's speech was not followed by the other law rods and was not binding. For novel situations, caparo tests should be used. Following Lord Bridge test, three requirements need to be satisfied. A. Foreseeability of damage, proximity between claimant and the defendant, and imposing of the duty of care has to be just, fair, and reasonable. An important basis for the duty of care in the tort of negligence is the Hadley-Byrne rule, commonly known as assumptions of responsibility. It was extended in Henderson versus Merit Syndicates Limited, not only to include statements but also provisions of services. The requirements for assumption of responsibility are as following. A person has some advantage over the claimant. The claimant must have relied on this assumption, and this reliance must be reasonable. The assumption does not have to be voluntary. Assumption and reliance will usually follow from contact between the claimant and the defendant. A well-known example is White versus Jones, in which the House of Lords acknowledged that the solicitor may owe duty of care to a third party. Caparo and Hadley-Byrne tests are interrelated, hence, two tests will be applied one next to another. As Hadley-Byrne provides a more specific test, it will usually be the first choice, leaving caparo as a rule of a last resort. A duty of care in negligence is generally not problematic if a person actively causes another person death, personal injury, or property loss. However, the duty of care is problematic in liability areas such as psychiatric injury, pure economic loss, and omissions. A duty of care to prevent psychiatric injury is not problematic if the victim has also suffered physical harm. Secondary victims will have to prove that they have a close tie of love with the primary victim and has personally witnessed the accident or its immediate aftermath. In regard with to omissions, the principle in English law is that there is no duty to act unless one of the exceptions established in the case law applies. Hence, a duty of care may be established if the defendant has created the risk, if he assumed responsibility for the claimant's welfare, or if the statutes of the defendant give rise to the duty. Economic loss consequential upon physical injury or property loss is not a problem. There is, however, no duty of care to prevent pure economic loss unless the defendant has assumed responsibility for claimant's welfare, or if caparo case exception applies, that is the duty to provide correct information to the intended parties and loss was incurred while using the statement. Another tort category is trespass to person, which involves direct and intentional interference with a person's body or liberty. Most of these torts are actionable per se, which means that the claimant does not have to prove damage. Proof of the committed tort is sufficient. Lord Denning and Latang and Cooper clarify that trespass to person needs to be intentional. Battery is the unlawful intentional touching of another. The unlawful contact must be intended, not the consequential damage. Also, touching needs to be a positive act. However, in Collins versus Wilcock, it was decided that most of the physical contacts of ordinary life are not actionable because they are impliedly consented to by all those who move in society. Assault is creation of reasonable apprehension of imminent battery. The threat must be real. Historically, assault required bodily movement. This changed with R versus Ireland and Barstow, in which a person made silent phone calls to several women who then suffered from depression. Today, Protection from Harassment Act 1997 may provide a firmer statutory footing for a claim. To personal autonomy is given more importance. A person of sound mind has the right to refuse the treatment, even if it would have very serious consequences for their health. Defamation encompasses the tort of legal, defamatory statement which was permanent in invisible form, and slander, a temporary and audible statement which is sufficient for liability. The classic test for the defamatory statement is whether the words tend to lower the plaintiff in the estimation of right-thinking members of society generally. Lord Scranton stated that a man is liable for the reasonable interferences to be drawn from the words used, whether he foresaw them or not. This implies that the tort is strict. There are various defenses: absolute privilege for statements in Parliament. Justification requires proof that the statement was factually correct. Fair comment defense is subject to the test of honest comment. Namely, would any honest man have written this criticism? Qualified privilege applies if there is a professional or moral duty to communicate and a public interest to receive the information. The defense is mainly used by journalists and academics and plays a major role in protecting the freedom of expression. If there is qualified privilege, the question is if the manner in which the information was gathered and published was responsible and fair. In England, road traffic liability is negligence liability with high standard of care. In case Nethership versus Watson, the conduct of a driver was experienced when conduct of an experienced driver. In the case N-P versus Lee-Chintat, it was established that the res ipsa loquitur principles only implies that if the defendant does not adduce evidence, the claimant has proved his case, which is different from the road traffic liability in France, where there is strict absolute liability, in Germany, full liability with reverse burden of proof. Another difference is that in England there is a full contributory negligence applicable.
Were under pressure to deviate from the French Civil Code, where the sole general rule for fault liability was applied. It was a result of the desire to strengthen the unity of the young German Empire. Moreover, it was thought that the general rule would lead to uncertainties and doubts, and particularly to the lack of boundaries. Since German nation is known for its pragmatism, the English law position, where only specific rules are to be drafted, was also considered inadequate. Accordingly, an intermediate approach was applied by a German legislator, designing 3 general rules with a restricted scope of application. Those rules can be found in paragraph 823 subparagraph 1, paragraph 823 subparagraph 2, and paragraph 826 BGB. Each of the provisions encompasses 5 requirements. The first requirement is the violation of a codified normative rule, Tatbestand, that restricts the field of application of the general provisions. Respectively, paragraph 823 subparagraph 1 requires the infringement of a right, such as the right to life, bodily integrity, health, freedom, or property. Moreover, Bundesgerichtshof, Federal Court of Justice, which is the highest appellate court in civil and criminal cases, has broadened the scope of paragraph 823 subparagraph 1 by incorporating a right to business into the protected rights. Furthermore, the general right of personality has been recognized in the case law of Bundesgerichtshof since 1954, not only as a basic right constitutionally guaranteed by Article 1 and Article 2 of the Basic Law, but also the rights that are not explicitly mentioned in the paragraph 823 subparagraph 1, but shall fall under the scope of other rights protected under this provision. Paragraph 823 subparagraph 21 subparagraph 2 requires violation of statutory rule. On the other hand, paragraph 826 requires intentional unethical conduct, contra bonus mores. Paragraph 826, however, unlike paragraphs 823 1 and 2, requires intention. Therefore, negligence is not sufficient to apply this paragraph. The next requirement is unlawfulness. If person has fulfilled the Tatbestand, it means that his conduct is in principle unlawful, unless there is a justification. There are three possible justifications: self-defense, codified in paragraph 227, necessity in paragraph 228 and 904, and self-help that can be found in paragraphs 229 and 859. Third requirement is fault. It is fulfilled if the wrongdoer acted intentionally or negligently, where German law assesses negligence in the sense of paragraph 276. By applying the objective test, where usually the standard of reference is a careful person of average circumspection and capability, unless the case concerns professionals where required standard is sufficient if he exercises the ordinary skill of an ordinary competent man exercising the law. In case of a direct infringement, the situation is straightforward. However, in case of an indirect infringement, the difference between unlawfulness and negligence is not obvious. In general, German courts have developed safety duties in all areas of accident law. In principle, in case of an indirect infringement, the breach of such a safety duty determines unlawfulness. Next two requirements are causation and damage, meaning that there must be a causal link between the unlawful act or omission and the damage that occurs. You may wonder whether personal liability deals only with fault liability. In fact, personal liability, in the meaning of liability for one's own conduct, in the German system can be found not only in the areas traditionally dealing with fault liability approach, but also a good example is Straßenverkehrsgesetz, German Road Traffic Act. To some extent, it covers liability for one's own conduct. In principle, strict liability regime for damage caused by a motor vehicle is embodied in paragraph 7 of Road Traffic Act, which holds that the keeper of a motor vehicle is strictly liable for damage caused by the risk of its operation, unless he can prove an external cause. The keeper shall be understood as a person who has supervision of the motor vehicle. Usually it's the owner. Therefore, by default, road traffic cases are dealt with strict liability approach. However, in cases where the driver is not the keeper, for example, a keeper's partner, the strict liability rule does not apply and focus is switched to the fault liability. In such a situation, the driver is liable for his own conduct in accordance with paragraph 18 of the Road Traffic Act, unless he proves that he did not cause the damage intentionally or negligently, meaning that we are dealing here with the reverse burden of proof. If the driver cannot prove a lack of intention or negligence, then he will be jointly liable with the keeper of the motor vehicle. After consulting different approaches to the personal liability in totally different jurisdictions, we've created a recommendation for the European Group on Tort as to how the provision of the personal liability should or could look like. A person, so the first paragraph, a person who intentionally or negligently, unlawfully injures the protected right of another person is liable to make compensation to other party for the damage arising from this. 2. Protected rights shall be understood as the right guaranteed by the ECHR. 3. A person is not to be held liable if the damage occurs as a result of A. Force majeure, B. Consent, C. Necessity, D. Self-defense, E. Fair or honest comment, F. Absolute parliamentary immunity, or G. Qualified privilege. Another article states that the person is liable for a violation of national statutory rule regardless of fault. Since we have already covered the liability for the acts, now we can switch to the liability for omissions. The provision states as follows. There shall be no duty to act unless A. Defendant has created risk, B. Defendant has explicitly or implicitly assumed responsibility for claimant's welfare, or C. A status of the defendant gives rise to a duty. Our next provision states that the victim of a road traffic accident in which a motor vehicle is involved has a right to compensation against the driver. However, if it is not possible to establish the identity of the driver, the keeper shall be liable for the damage. Accordingly, in terms of persons with diminished capacity, the provision states a person who has diminished or lack of capacity and caused damage to another is nonetheless liable to compensation. Since we've covered already the liability for the omissions and acts, now we can move to the liability in road traffic. Our provision states as follows. The victim of a road traffic accident in which a motor vehicle is involved has a right to compensation against the driver. However, if it is not possible to establish the identity of the driver, the keeper shall be liable for the damage. In terms of persons with diminished capacity, our provision says that the person who has diminished or lack of capacity and causes the damage to another is nonetheless liable for the compensation. In light of our discussion with all three countries, we've come to the conclusion that we should take the core for the fault liability from the German BGB, and then, in terms of road traffic, we switch to France, saying concerning persons with diminished capacity, and from England we took very specific part, which is liability for the omissions. Therefore, we think that altogether this provision satisfies more or less all three jurisdictions and therefore will be applied as one coherent provision for the European Tort.